Good morning or good afternoon to everyone, depending on where you are joining us from. Welcome to today's webinar on the role of the Fairness Commissioner, offices in Canada through an Ontario lens and some ways to advance fair registration practices. Before we begin our webinar today, we would like to begin with an acknowledgement that N4 is hosted at CHEO, which is located in Ottawa, Ontario. Ottawa is built on unceded Algonquin Anishinaabe territory. The peoples of the Algonquin Anishinaabe Nation have lived on this territory for millennia, and we honor them and this land. Their culture and presence have nurtured and continue to nurture this land. We also honor all First Nations, Inuit, and Métis peoples and their valuable past and present contributions to this land. My name is Mariah Maddock, and I will be hosting today's webinar. My co-host is Andrew Tomeyer, and Andrew will be monitoring the chat box and the question and answer box today. And I am now pleased to introduce to you today's presenter, Commissioner Irwin Glasburg. Commissioner, I'm going to ask that you turn on your video as I introduce you. Irwin is a lawyer and public servant who began his career at the Ontario Ministry of Labour in the occupational health and safety field. He then moved to the Ontario Workers' Compensation Board, serving first as the Chief of Staff to the Chair, and then in a number of executive-level policy, legal, and finance positions. Subsequently, he joined the Information and Privacy Commissioner as Director of Appeals. He was then appointed as the Assistant Information Commissioner, the most senior adjudicative position in the organization. Irwin has worked at Cabinet Office in the Ontario government on two separate occasions. First, as the Executive Coordinator responsible for the intergovernmental, municipal, and justice portfolios, and later as the Assistant Deputy Minister for the Roots of Youth Violence Review. He also held a variety of executive-level positions at the Ontario Ministry of the Attorney General, where he was responsible for the Victims and Vulnerable Persons Policy and Adjudicative Tribunals and Civil Law Divisions. For a 3-year period, he also co-chaired the Debwewin, meaning Truth in Ojibwe, Jury Review Implementation Committee in conjunction with Grand Chief Alvin Fiddler of the Anishinaabe Aski Nation. Irwin was also appointed as Ontario's Deputy Attorney General on two separate occasions, in 2017 and most recently in 2020. Irwin holds a Bachelor of Arts degree from McGill University and also a Bachelor of Law degree from the University of Toronto. He is also a graduate of the Ivy Senior Public Sector Leadership Program at the University of Western Ontario. Welcome, Commissioner. We're so pleased that you're joining us today.
Mariah, thank you so much for that kind introduction, and thank you to everyone for joining this webinar. I'd also like to thank Angelica Noenhoffen and Aaliyah Correa, who helped put this slide deck together. So maybe we can proceed to page 2 of the deck.
Wonderful, and I will share your screen and just remind everyone that they can participate through the question and answer box today. And over to you, Irwin.
Great, so let's move to the next slide, Mariah. So the title of this presentation is the role of fairness commissioners and offices in Canada through an Ontario lens, and some ways to advance fair registration practices. They're slightly different topics, but I do believe that they hang together. So there's currently 7 fairness commissioners or fairness offices across the country. 3 original ones were in Ontario, Quebec, and Manitoba. Then Nova Scotia joined, Alberta, British Columbia, and most recently Saskatchewan. So these offices have now been institutionalized in most jurisdictions in Canada. So the general mandate of these offices is to ensure that the registration practices of professional regulators, and in some cases, skilled trades, are transparent, objective, impartial, and fair. In all jurisdictions except British Columbia, it's the regulator that essentially has the final authority or say to establish its registration processes. In British Columbia, the superintendent of governments can direct the regulator to adjust its registration processes. All of the fairness offices get together periodically in an organization called the Registration Oversight Forum, where issues of mutual interest are discussed. So let's go to the next slide, Mariah, which is a graphic on the evolution of fair access legislation in Ontario. So there was a report in 2004 that led to the introduction of legislation, which we call the Fair Access to Regulated Professions and Compulsory Trades Act. Over time, new professions joined in. Our office became part of the Ontario Public Service. More recently, we've launched a risk-informed compliance framework, and there have been amendments to our legislation. Next slide, please. So we were the first province to adopt fair registration practices legislation. And this slide simply presents the trajectory of other jurisdictions that have joined subsequently. Let's go to the next slide, please. So I've provided some details on the next few pages about some unique aspects of the legislation in other provinces. Each has been shaped by the imperatives of its own jurisdiction and I guess approaches for the establishment of oversight agencies. Manitoba has always been a fierce advocate for fair registration practices. Recently, there have been some amendments to the statute, two of which I'm going to mention. The first requires that a regulator must establish that its registration requirements are necessary. It might seem like an odd provision, but it does place an obligation on regulators to really take a look at how they manage their processes to make sure that components do not constitute barriers that cannot be justified on logical grounds. And the second is to take reasonable measures to work with educators and employers to ensure remedial opportunities for applicants. It's an important provision because it begins to draw in the education and employment sectors and provides a heightened obligation on regulators to help ensure that applicants succeed. Last bullet talks a bit about the Nova Scotia scheme. What's neat about that is that the Nova Scotia agency has established a number of what I call big tables, which bring together folks from immigration, settlement, registration, licensure, the employers, in structured conversations with respect to particular professions, and ensuring that the left hand knows what the right is doing and developing a level of system coherence. So let's go to slide 6, where I talk a little bit about the British Columbia model, which is a bit different from the others because the Manitoba agency oversees governance of regulators, broadly speaking, and as I mentioned earlier, is able to substitute its approach where it feels that a regulator's practices are not appropriate. Let's go to slide 7, please. And the Quebec scheme is unique as well. It encompasses responsibility for 46 regulatory bodies and 55 professions. It reviews admissions processes of professions, including access to the academic and practical training required for recognition of competencies, and generally has quite broad oversight over third-party service providers, universities and colleges, and employers. So that's a high-level analysis. I have provided the references for the legislative provisions, and if you're interested, I encourage you to undertake a bit more research. So let's go to slide 8, please. Here I talk a bit about the Office of the Ontario Fairness Commissioner, for which I am responsible. And our mandate, broadly speaking, is to help ensure that the registration practices of regulated professions, health professional colleges, and Skilled Trades Ontario, which is an umbrella body for the skilled trades in Ontario, adhere to fair registration practices. We operate under two statutes, the Fair Access to Regulated Professions Act, which we call FARPACTA for short, and a schedule under the Regulated Health Professions Act, which applies to the health regulators. Among other things, our statute requires that regulators develop registration practices that are transparent, objective, impartial, and fair, provide information to applicants, make information publicly available on what documentation or qualifications must accompany an application, along with acceptable alternatives, to train individuals who make assessment and registration decisions, and to ensure that those decisions are made in a timely fashion. Let's go to page 9. So the statutes provide a list of functions for the Fairness Commissioner, and ostensibly our role is to review the registration practices that regulated professions and third-party service providers employ to assess the qualifications of individuals. We offer advice to regulated professions on how to comply with the legislation, and we provide advice to responsible ministers. The legislation confers upon the Fairness Commissioner a broad array of powers, including the authority to require that regulators provide reports on a number of defined topics. I can also issue orders to the non-health regulators and recommend that prosecutions be undertaken. In the health sector, however, I am limited to providing compliance-related advice to the Minister of Health. There's a lot of work that we do that is not actually articulated in the statute. We perform a lot of advocacy work respecting fair registration issues, particularly relating to internationally trained applicants. This may involve touch points with upstream and downstream organizations in such spheres as immigration, post-secondary education, and settlement and integration services. We often work behind the scenes to influence government action. For example, we recently suggested a number of legislative amendments to our FARPACTA statute that were subsequently enacted. And we do our best to influence policy formulation within the Ministry of Health. And so we act as a bridge between stakeholders and government ministries, and in our role as trusted advisors. There are occasions where we are listened to and others where we aren't, but that's a critical role that we play. We are also very active in collecting and disseminating best practices, really to help ensure that the whole is more than the sum of the parts. Where we come across issues that are challenging for a number of regulators, we'll take steps to try to bring them together and share new ideas. For example, we've done a number of seminars on diversity, inclusion, and anti-racism issues, one in particular on the collection of race-based data. So let's go to to slide 11, please. Next one, please. So this slide provides a snapshot of the health colleges for which we are responsible. You'll see that there are a lot of them. And I think historically in Ontario, there's been a proliferation of these colleges where a group feels that they should become professions applied to the ministry and certain criteria are met. They are. You'll note that there are 4 discrete professions in the dental area, for example. The trends we're seeing in Western Canada relate more to a collapsing of like regulators. Let's go to the next slide, please. And this slide identifies the non-health regulators, and they're soup to nuts, from engineers to lawyers to accountants to veterinarians. In the Ministry of Health, for the health-related colleges, the ministry does perform its own oversight and coordination role. For example, the regulators are required to provide performance measures that the ministry identifies. So there is coordination, and we share that regulatory space with the Ministry of Health. In the non-health sector, there are 7 what we call oversight ministries that are responsible for the statutes of these regulators. And so there's a lot less coherence in this sector. And one of the approaches we've taken to manage the oversight of the 41 regulators we have is to develop what we call a risk-informed compliance framework, where we look to historical performance of the regulators and mate that with a list of forward-looking risk factors and come up with a risk category, and that dictates how much attention we pay to the regulators. Next slide, please. So this is a numerical slide. It contains data from 2020 about the numbers of people who move through the system. These numbers were depressed a bit because of COVID, but they provide kind of a general sense of volume. Regulators received about 80,000 applications. 72% of those came from domestically trained applicants. There were 5% from domestic labor mobility applicants, and another 21% originated from individuals who are educated internationally. So let's go to slide 14, please. And here, I'm going to introduce the concept of the fair access registration ecosystem. So a lot of processes are called ecosystems. So I think fair registration also falls within those parameters. So why not call this an ecosystem as well? So there's some context here. And that is that the available statistics indicate that Ontario's workplace is aging. Experts agree that the province requires trained workers to replenish employees who have retired or are about to leave the workplace. Net migration derived from both immigration and interprovincial movement is projected to account for a full 83% of all population growth in the province for the foreseeable future. This means that only 17% of the growth will come from in-province increases to population. And the more recent statistics that I have seen paint an even more, I would say, aggressive picture of the importance of immigration to our workforce in Canada. And so the upshot is of this, in an environment where we are going to rely much more on immigrants, is that we have to redouble our efforts to remove barriers that unnecessarily restrict access for internationally trained individuals and those coming from other provinces, as this will increasingly become an important component of the government's strategic labor market plan. Next slide, please. So we're going to throw up a graphic in a second where we try to describe the ecosystem. It's actually much more complicated, I think, than what we're trying to convey, but it does depict the complexity of the individual's journey as they move through various stages of the immigration, education, credentials, assessment, registration, and employment processes. And the upshot is that everyone involved must work to improve coordination among the various players involved in this process to help ensure that more applicants can more easily move through the steps in the process and obtain high quality jobs. And I know that N4, many of you are advocates for this process. So let's go to slide 16, please. So this is the ecosystem, and you can see there's arrows going in a clockwise direction. We start at the top left-hand quadrant where people immigrate. They are accepted to come to Canada through the various streams. They go through the settlement system. There's bridge training programs. They improve their language proficiency where that's necessary. And they reach a point where they apply to a profession or trade. Usually the first step is a third-party service provider that assesses credentials and makes some recommendations regarding equivalency. And then you fall into the lap of the regulator, which will have a variety of steps in its process that hopefully will lead to licensure. There'll be opportunities for applicants to improve their educational credentials where gaps are identified. And then they move into the labor market and employment sector, where the objective is to find employment that relates to the skills and training that they have spent many years acquiring in another jurisdiction. And so we have some stuff going on in the center of this ecosystem. There's a Venn diagram where we talk about fairness commissioners, other oversight ministries that are involved in the process, other government agencies, ministries, the federal government, municipal government. So there's a lot of players involved in this process. And it's there just to underscore that this is a complex process, a lot of players, and they have to work together. Let's go to slide 17. So I wanted just to talk briefly about some very recent legislative amendments in Ontario, which were designed to address gaps in our current legislative framework relating particularly to internationally trained individuals seeking to be registered. So very broadly, there were four new provisions. The first prohibits Canadian experience as a requirement for registration, except where a regulator can establish that this program is necessary for public health and safety reasons. The second eliminates duplication of language proficiency requirements. This was an issue that I felt very strongly about because it seemed to me that that applicants needed to face sort of a litany of language requirement provisions that weren't coordinated, that this whole process wasn't being looked at through the lens of the applicant. So the upshot of this provision is that regulators must accept test results from service delivery agencies that IRCC has endorsed, and where a language test has already taken upstream. The regulator, however, can impose a different passing requirement. In addition, these language tests don't time out, so that if an applicant has started the registration process with a valid passing score, then it's good till the end of the process. We were seeing situations where applicants were almost at the finish line and boom, they had to take another test. So that was a bit of a problem. There's a provision which creates a time limit of 6 months for regulators to make registration decisions once an applicant's file is complete. And I want to be transparent about this provision. It does not necessarily include the assessment work that is undertaken prior to the regulator receiving the report. And we know that much time is often spent meeting the requirements of third-party service providers. And finally, in response to some situations, unfortunate situations that arose during COVID-19, regulators are required to have plans in place to ensure continuity of registration practices. Now, these provisions apply to the non-health professions. Our government has since passed similar but not identical amendments that apply to the health regulatory colleges. Next slide, please. So there's now four issues that I wanted to talk about. Some of this will be provocative in nature, and I hope it will generate some good discussion. And these are the impact of the Canadian Charter on fair registration practices, the government's increasing focus on filling job vacancies, what I call the documentation roadblock, and finally, provisional registration as a method to get internationally trained professionals on the job. So let's start with the charter on page 19. And I want to go over a particular case that was recently decided in Ontario. Today is really interesting. So the diversity, equity, and anti-racism landscape across Ontario is influenced by court and tribunal decisions that consider the practices of professional regulators in health colleges. And one such decision was issued by the Ontario Superior Court of Justice, the Divisional Court, called Ontario Teacher Candidates Council and the Queen. And there, the court carefully explored the application of the charter to the mathematics proficiency test, MPT for short, administered by the Ontario College of Teachers. This is a relatively new standardized math test that all candidates were historically required to pass to become certified as teachers in Ontario. The applicants in this case were individuals who wished to join the teaching profession, and they sought a declaration from the court that this test and the legislative provisions requiring it violated Section 15.1 of the Charter, which specifies that every individual has the right to equal protection of the law without discrimination based on race, national or ethnic origin, etc. The court was required, I'm on page 20 now, to decide whether this test had a disproportionate adverse impact on entry to the teaching profession for racialized teacher candidates. The evidence pointed to significant disparities in success rates on this testing for teachers based on race, including statistical evidence of racial disparities with respect to the MPT in particular. The court ruled that the test infringed Section 15.1 of the Charter and could not be justified under Section 1 based on reasonable legal limits that could be justified in a free and democratic society. It further concluded that the government did not discharge its burden of showing that the MPT minimally impairs the rights of racialized teacher candidates, and alternatives or substitutes for the MPT were not reasonably available. I am going into the charter lingo a bit. I just think it's important to have the context. The court commented that there is an underrepresentation of racialized teachers in Ontario schools, and that racialized students benefit from being taught by racialized teachers. the court concluded that the legislative provisions that created the MPT were of no force and effect. Now, since this decision was issued, the Ontario government has successfully sought leave to appeal this decision to the Ontario Court of Appeal, and the court will ultimately make a decision. However, owing to the way the lower court's decision was framed, this test is no longer a requirement to become a teacher in Ontario. So I'm on page 21, and I talk about some of the implications of this decision. I think particularly if the Court of Appeal endorses the decision, regulators will need to consider whether their current testing methodologies create differential impacts on racialized applicants from different national or ethnic origins or of color, which are also charter protected backgrounds, and whether they need to collect race-based data to inform that analysis. The availability of such data would materially assist regulators to refute allegations that their testing methodologies create differential impacts on racialized communities. In addition, if a regulator's testing methodology routinely scores internationally trained applicants lower than domestic ones, the regulator should consider whether its approaches are unnecessarily penalizing these candidates without giving them credit for other competencies and experience that they bring to their work. As a corollary, regulators should routinely exercise flexibility in assessing test scores, especially for internationally trained applicants who are close to achieving a passing grade. In other words, it's necessary to consider the characteristics of the test taker, not just their score. And they should also consider the applicability of sections 15.2 of the Charter and applicable provisions of provincial human rights codes, which provide them with legal flexibility to establish programs that ameliorate, relieve hardship or disadvantage, or achieve equal opportunity for those whose rights are protected. So I guess what I'm saying here is that regulators have the opportunity to work with applicants who may not have passed an examination, but who are close. You know, I ask regulators what they will do in situations such as this. And the responses range from too bad to sad to, well, they'll have another chance to write the exam, to, you know, well, we're going to sit down with this applicant. We're going to mentor this person. We're going to provide wraparound services because it's a tragedy for somebody to pull up their roots, come to Canada, and not be able to apply their profession because they haven't passed the exam within hailing distance. So I think that there needs to be a real change in mindset among regulators that, you know, the psychometric considerations of test score is not the holy grail. There's more to it than that. And it's an issue I feel very, very strongly about. And I just think it's a tragedy to waste the talent that comes into this country based on these sorts of rules. Call me heretical, but I just don't think the testing is the end all. So I want to go to page 22 now to talk about the focus of governments on filling job vacancies. So you'll know that governments are now much more focused on filling jobs that require skilled professionals and tradespersons. In our province alone, hundreds of thousands of these jobs are not filled. And governments are becoming more proactive in dealing with this issue because it creates political problems for them. In Michigan and Nevada, for example, state governments have leapfrogged regulators to ease restrictions on hiring internationally trained teachers. In our province, our Minister of Health, the Honorable Sylvia Jones, gave the College of Nurses and the College of Physicians and Surgeons 2 weeks to come up with plans to expedite the registration of internationally trained applicants. And the colleges came up with some innovative new ideas. In the case of the nurses, regulations have already been acted, and the government is considering the CPSO's recommendations regarding physicians. Two takeaways. First, labor supply shortages will motivate government to take decisive action. And second, regulators need to rethink how they integrate labor market considerations into their statutory mandates. Whereas historically, I'm on page 23, there's been a fairly narrow interpretation of public health and safety where there's a risk of harm to the patient. I'm not diminishing that at all. However, I do think there are new considerations relating to an undersupply of professionals. For example, think of a scenario where your local emergency ward needs to close because you don't have a sufficient number of nurses. So this whole concept of public health needs to be reconceptualized. I think also growing disconnect between our immigration policies in the country, which are designed to bring more and more immigrants, skilled immigrants into Canada, and the processes of regulators that almost put the brakes on. So those two approaches, those two philosophies, I do not think can continue to coexist, and puts a premium on ecosystem thinking and discussions, and everyone must advocate for more coherent, fair, and efficient systems. So two more items before I close. The first is what I call the documentation roadblock. And usually the first step in an assessment process is for a regulator or a third-party service provider to get the documents. Our office did a study some years ago where it found that for 24% of internationally trained applicants, it took more than 6 months to obtain the materials, and for an additional 52%, from 1 to 6 months. So, and often the whole process stops until the documents arrive. It's called a serial processing approach. We're very much advocating for parallel processing, and so when applicants application come in and they come from a jurisdiction or an institution where there aren't concerns about fraud, we're encouraging regulators to take a risk-informed approach, let this person through the gate, through the next steps in the process until the documents catch up. And that's going to potentially save many months of processing time. I want to talk finally about provisional registration on page 25 of the deck. And there's a typo in the first bullet. It should read, our office also takes the position that full or permanent registration into a profession should not, the not's missing, should not form a bright line as to when internationally trained applicants can begin to actively contribute to their profession and when they cannot. And as case in point, in response to Minister Jones' directive, the College of Nurses of Ontario recommended that the government amend its registration regulation to enable the college to potentially register close to 5,000 internationally trained nurses in a temporary class, subject to completing any outstanding requirements. And the nurses would remain in that class while completing what was needed, and then jump to the general class. And so this approach was endorsed. I believe, and I'm page 26, that this approach hits a public interest sweet spot, since it protects public health and safety in the way I've defined it previously, and helps to move a highly competent cohort of internationally educated nurses through the registration process by removing roadblocks. It also recognizes that all professionals are subject to a learning continuum where the skills and experiential learning need to be continually upgraded at all stages of their careers. And our office will actively encourage professions and trades to place greater reliance on provisional registration and related strategies to move internationally trained applicants through the registration process more seamlessly. In other words, the drawbridge must come down. I'll close with one final thought. Many of us in this room have been advocating for internationally trained applicants for a very long time. It has, at times, been a lonely and frustrating process. Coupled with the aftermath of COVID-19, I see the landscape slowly shifting. Governments are starting to take action, the courts are leaning in, and organizations that have remained on the sidelines are offering their support. Two recent examples in one in Ontario, where Professional Engineers of Ontario, where its council, its board of directors, unanimously voted to do away with the Canadian experience requirement. And this was from a profession that had been sort of steadfastly attached to that provision. Very significant. And recently we've learned that in British Columbia, government is tripling the number of spots available for practice-ready assessments. Highly encouraging. And so I think we're at a tipping point. And I encourage people who are advocating for internationally trained applicants who are in that position themselves to continue to add your voice to the dialogue because it's working. Thank you very much.
Wonderful. Thank you so much, Commissioner. This was such a fascinating and thought-provoking presentation. It was very well laid out. And I can see that there's several questions in the question and answer box. So I'll start at the top. I also encourage those who are participating today, just a reminder that you can upvote questions that you're interested in hearing the answer to, and I'll prioritize those questions to ask to the Commissioner first. So our first question is, how would you characterize the relationship between regulators and the Office of the Fairness Commissioner over the last 10 years? In your opinion, has this relationship changed over time?
So I would say that historically our relationship has been frosty. And I think that has been the case because our statute is one that is focused on getting regulators to churn out reports. We have an audit function. We did a full audit of all of our professions many years ago. Regulators didn't feel that it added value. I don't think that we were viewed as strategic partners. We've moved recently to a risk-informed compliance framework because we have 41 regulators and only a handful of compliance analysts, and we said to ourselves, we have to find a way to zero in on the regulators that are most problematic and to focus our resources on them. And we developed that framework in consultation not only with regulators, but the immigration and settlement community and other experts, where we look at historical performance and risk factors, one of which is sort of labor market issues, supply and demand and that sort of thing. And we did a client satisfaction survey some months ago, and I think regulators have reacted very favorably to us. I mean, we are a traditional regulator. We can go in and for some regulators issue orders, but we also view ourselves as strategic advisors and trying to do what we can to nudge regulators to do the right thing, let them know what's going on elsewhere. So I would say that the relationship has improved.
Thank you. And what were some of the biggest challenges regulators faced during COVID, and how did they respond?
Well, I mean, I feel most regulators really did a great job. Some had really modernized their application processes. So people could interact electronically, which really helped. Others pivoted to this new approach really quickly. So I think from that dimension, they did well. COVID also really laid bare some problems with inflexible regulatory provisions, mostly in the health sector, where some regulations talk about non-exemptable provisions, which it's hard for a regulator registration committee to get around. And the only way you can fix it is through regulation. The pharmacist successfully got a change, but if a regulator was not agile or had too conservative a mentality, people were just stuck. Internationally trained applicants were stuck. We had a situation with one regulator where their third-party service provider just threw the towel in because it was wanting to do virtual OSCEs, objective structured clinical examinations, and failed. And result was about 100 internationally trained applicants were left in limbo, which is tragic. It also, I think, underscored the advantages and disadvantages of in-person as opposed to virtually proctored examinations. I mean, our view is that applicants should have choice. The advantages of a proctored exam is that individuals don't have to travel to the exam center. They can take the exam at home. I know for some it is very stressful, but so that's one issue. And we also had several examples of cheating on examinations, both the Law Society of Ontario and the National Dental Examining Board. And that cheating was the product, I would say, mostly of the virtual environment, but I think is potentially a deeper issue as well that cuts to the integrity of the examination process. And some regulators do a better job at having an inventory of exam questions. And if there's a breach, you can set a new exam up pretty quickly. Others don't. And that can create serious problems for candidates.
Thank you for that detailed response. And the next question is from an individual asking if someone resides in Alberta, yet their regulating body is a national body that's situated solely in Ontario, would that regulatory body only comply with the Ontario Fairness Registration Act?
Well, I believe what our statute indicates is that the third parties are required to apply the same principles contained in our statute to the process. Under our legislation, we regulate professional regulators, but we can only monitor third-party service providers. We can ask for information. We can't direct them to do anything. And we have been working with regulators to help them modernize the contractual provisions that they have with third-party service providers to ensure that they are consistent with our legislation and deal with issues like privacy and cybersecurity, and give applicants recourse if they disagree with a decision from the third-party service provider.
Great, thank you. And does the Fairness Commissioner have any thoughts or a role to play in ensuring that boards of the regulatory bodies have adequate representation of internationally educated members?
Well, I think it's a great point. And we're not we're not responsible for the governance of these bodies or um, appointment of members. But when you think about it, really most modern organizations are really focused on their clients. Now, some regulators may not view an internationally trained applicant as a client, as opposed to someone who's just moving through the system like a traditional school system. But I do think that for regulators to be responsible, they need to understand what's in the head of the applicants. How is the process straightforward? What are the problems? And there are a variety of things that a regulator can do to establishing a bit of an advisory group, or the suggestion that the individual has made, which I think is a great one, and I'd like to think about it and take it back. There are some professions where students or internationally trained applicants are more coherently organized than others. I would say the physicians are one such group. The dentists are another such group. Others are not organized. And like when you think about it, it can be quite a transitory state that an internationally trained applicant is in the sense you're involved with a regulator probably for no longer than is absolutely necessary. If you're through the gate, you have another relationship with the regulator as a member, right? And if you're unsuccessful, then there are other consequences. But I think understanding the voice of your clients is really important.
Great. Thank you. Thank you for that response. And there's a follow-up question here related to some remarks that you made on testing integrity. So the participant is commenting that testing integrity is clearly important for professional competency assessment. It seems Canada has been leaning into US testing systems to address this, for example, the RN-CLEX for nurses. Do you have any concerns about testing processes being administered through groups in the United States?
I don't personally. I know we've had some issues in some of our health colleges where there was a concern that an Ontario or Canadian testing body didn't, if competition was allowed from an American body, that the fiscal viability of the Canadian entity might suffer. I thought, on the other hand, having two bodies available gave applicants more choice. So I and provided both were, reliable, and I think there's merit to choice. I wanted just to turn to this question about testing, and we've done some work with our Royal College of Dental Surgeons and the National Dental Examining Board, which is a third-party service provider. And this was in the context of the cheating scandal for their knowledge exams. And we learned a little bit about what was an acceptable pass rate, which is psychometrically validated, in a way is based on what domestic candidates, how they would likely score in an exam. And what we were told, and I may not have the statistic right, is a 43% pass rate on the first exam for internationally trained applicants is psychometrically valid. So this is a statistic in place that's not challenged by anything else, like how many dentists do you actually need in Canada, particularly since the federal government is rolling out new dental plans. So that 43% is okay. But what about the 57% of internationally trained dentists who have failed. Do we not care that 6 out of 10 may be precluded from practicing their profession in Canada after they've pulled up roots, come here, spent thousands and thousands of dollars? Probably the dental profession is the one that is most expensive to move through. So I guess I am challenging the paradigm of psychometric validity. Of course, it's important. We need competent, we need qualified practitioners. But what's the cost of that model on the other side? If so many people are falling to the wayside, we don't have a strategy to deal with them. So I think you need a bit more holistic thinking, which needs to integrate labor market requirements of the country, which may dictate more dentists rather than less, and protecting the public. That's the balance that I think is missing, and we need more conversations about that.
Yeah, thank you. What a provocative question. Thank you for leaving us with that. Unfortunately, we're approaching the end of our time together. But I want to thank you, Commissioner, for sharing all of your wisdom with us and also telling us what the Office of Fairness Commissioner does to ensure and work towards fair registration practices in Ontario. I also want to make note of some upcoming N4 events that we invite everyone to participate in. On December 14th, we're featuring an innovative model to support IENs into practice at Sunnybrook Hospital. And on January 18th, a webinar related to virtual care. We've also curated several resources to accompany this webinar topic, and we will be sharing a recording with you and all those who registered as soon as it is available. As well, we look forward to hearing your feedback. We have created a post-webinar survey, and that will pop up in your browser. We appreciate any further feedback that you may have for us. And I want to leave you, Commissioner, with the final words. If there's one key message that you could leave with those who are attending today, what would that be?
I would say continue your advocacy work. It's important and it's working.
Great. Thank you very much for that message. And once again, thank you to everyone for joining us. We hope to see you at a future N4 event.